And joining us now on the debate in Calgary, Alberta, Gene Cumming, Editor-in-Chief of Lexpert, an information service about the business of law. And back here in our studios, Raymond Wyant, Provincial Court Judge in Manitoba, once that province's Chief Judge. Jamie Chafe, President of the Canadian Association of Crown Counsel. William Trudell, Chair of the Canadian Council of Criminal Defence Lawyers. And Mayo Moran, Dean at the University of Toronto Law School. And it's great to welcome everybody around this table. And Jeannie, we miss you being here at the table, but we're happy you could find some time for us on the line out in Calgary. It's nice to see you again. Well, let's just do this off the top, because some of our sharper viewers may remember, Judge Wyant, that you were here once before, and I introduced you then as the Chief Judge in Manitoba. Right. And you're not anymore. And we don't want anybody to be under the misapprehension that you somehow got fired or demoted. That's a rotating honor in your province, and as a result, it's somebody else's now, but we're glad you're here.
Thanks, Steve.
That sum it
Great
up?
to be here. Absolutely.
Okay. About a week and a half ago, the Attorney General of Ontario, I think, surprised a lot of people in your profession when he said the following when asked about cameras in the courtroom. He said, "I'm open. I know in the United States we see things televised all the time. There's very much a culture of televising. Society doesn't seem to have fallen apart as a result of it, although we're probably a long way away from that reality," he added. "I'm prepared to speak with the judiciary about their interest in having the discussion at this point in time, where we would go, and canvass the views of other participants in the justice system." Okay, let's do that tonight. That's what the Attorney General has suggested. He said we should get some input from the judiciary. I got a judge right here. If he asked you about the advisability of putting cameras in the courts, what would you tell him?
I tell them that our judicial system started years ago with trials in the public square, Steve. Our judicial system, in fact, is an open system, and we have open courts. But we build buildings where people can't come, they're not unable to come, and it's about time that we use technology as we use it everywhere else in society to open up the courtrooms so that people get a better understanding of the justice system. And I think with particular limitations and rules, we can do it quite effectively.
So there's one yes from one judge. How widespread among the judiciary is that opinion, do you think?
I don't know that it's widespread. I think that there's a movement among the judiciary to introduce cameras in the courtroom on a limited basis in certain types of matters, particularly in appellate courts, to open them up, to open cameras up where there are trials with witnesses. I think probably doesn't curry much favor with judges across the country at this point in time.
Gotcha. Okay, Jamie, you represent the Crown attorneys. How do you think they'd feel having people watch them on TV every day they do their jobs?
Well, Crown attorneys are used to speaking in public. I think their primary concern would be on the integrity of the process and our ability to get witnesses to come and testify. Those are people that often have only one brush with the criminal justice system and are already, in many cases, reluctant to come forward. And adding cameras would be an added pressure, certainly. And
I'm going to talk more about that angle in a second. I mean, the Crowns themselves, would they object to being on television?
I think that we do have certain security concerns. We certainly want to have the ability to consent to going on camera, and we'd like our voice to be heard in this discussion.
Is that a no?
That's a considered no, I think.
A considered no?
Yes.
Meaning it's no, but you're open to some discussion about this?
As long as the integrity of the trial process can be protected. It is a truth-seeking process after all. As long as the security of the participants can be assured, then I can see some Crown attorneys being willing to do it, but they're going to want to have the ability to consent and to say no.
Gotcha. Bill Trudell, you represent the people on the other side. You defend people in courts. Any sense about where the majority of the folks who do what you do are on this one?
I would think it's a bad idea and its time hasn't come. I think that's sort of the way we would feel about it. Not speaking for all defense counsel. Defense counsel aren't shy for publicity, but it's not our case. It's the accused case. We're talking about criminal cases and specifically right now. But the protection of the jurors, the privacy of the jurors, the accused person comes into the courtroom, they're accused of something, they may be found not guilty, they are allowed then to go back into their community. I'm very concerned about the lack of privacy, the lack of understanding, and people not happy about the verdicts. And so I think, I don't even think it's manageable. So quite frankly, I feel very strongly that we're not there yet.
So Jamie's a qualified no. You are a definite...
I'm a definite no.
Definite no, no point in even talking about it.
Do I go home now?
No, you get to stay and defend your position. That's fine. Okay. Okay, Mayo Moran, presumably you've had a chance to survey some of your fellow academics on this issue. Where are they on it?
Yes, so I surveyed my colleagues, and my colleagues rarely agree on anything, but they actually agreed on this, so it's interesting.
Which way?
What their view was that there should not be cameras in the courts in trials, and but for legal argument, particularly appellate cases and legal argument, they felt it was really great as a teaching tool, but with trials and with giving of evidence, they're concerned about privacy and other considerations along those lines.
So with appellate cases, you've only got judges in there. You don't have calling of witnesses. You don't have a jury.
Right.
So it's okay?
They're mixed on appellate cases. It depends on the nature of the case. They were very supportive of appellate cases' legal argument, closing argument, whether or not it should involve other argument. They weren't as clear because you can imagine family law cases, child custody, where you really wouldn't want that information out in the public, even though it might be an appellate case.
Gotcha. Okay, Jean, we've got one lonely judge in favor. We seem to have three others who are alternately definitely opposed or mildly opposed. Where are you going to come down on this?
And I'm going to come at it from the, looking at it from the media point of view, because you have such a wonderful survey of different vantage points there. And picking up on Dean Moran's point about most academics saying, let's do it with appellate court but not with trials. And it reminds me of the crime writer Elmore Leonard gives advice to would-be novelists and says, leave out the parts that people don't read. The trouble is that the trouble is that media, and I think that they're answering the public's appetite. Media want trials because some appeals can be a bit dull. So I think it's not going to answer if there is a public demand for it. It won't answer it to say, sure, you can do appeals, especially if it's legal arguments that don't involve families or other personal situations. So I think we're going to have to, I think the public want it, and I think there's a media taste for it. If you look at what's happening in the media, both in the US and Canada, on formerly Court TV is now in the US called True TV, and in Canada called Investigation Discovery. And in both cases, they're much more interested in the forensics, in the facts, in the, we might say the nasty bits. And so I think we're going to have to work in controls because that's what the people want.
Bill Trudell.
The public appetite is something that I wonder about, whether it's a public appetite or it's a media-driven appetite. I really don't think the media does as good a job as they could about explaining how the criminal justice system works. But this public appetite that the media professes, it's, what are we going to have, the amazing case? The public are interested in the CSI type situations that have been described, but there's a serenity about the criminal justice system, our court system. And
because TV's not there.
Yes, that's one of the primary reasons why there is, you go into this world, you're able to sort of have your cases pleaded, and you're without the exposure, pressure of outside forces. And I think that there's no public appetite that I know of, and I apologize, but you often, every time there's some issue, you find one of your sister networks in the courts questioning. Why can't we get in? Why, publication bans, for instance. Publication bans are usually just publication delays. You find out later. So there's a higher purpose that gets lost in talking about the public's appetite. I don't think the public's missing anything.
Judge Wyand.
Except this is the public's justice system. Let's not forget that. This is not the system for us. This is the public's justice system. And quite frankly, we've had cameras in the courtrooms in the United States for many, many years. And save and except for OJ, we haven't seen the OJ type of scenario repeating itself.
That seems to have traumatized so many people.
Sure it did, but it is really one in a million type of case. There are cameras all over courtrooms in the United States. People can't even see them when you walk into the courtroom. Cases are televised all the time, and no one's complaining about the integrity of the system being compromised. Sure, we have to have protections. We have to protect, we have to worry about security and protecting vulnerable people and witnesses and the integrity of the process. But you can establish rules. And when Bill says, well, the media, doesn't necessarily get it right, we rely right now on the media to interpret what happens in the courtroom, and then we complain. We internally complain when they don't get it right or they skewer things the way we don't like it. But if cameras are there, people can see directly what happens in the courtroom and make their own decisions.
Let me hear Mayo and then Jean.
Yeah, I was going to mention the O.J. Simpson case as an example of a situation where the concern was that the presence of media actually distorted the nature of the legal process. And I think there is definitely that concern remaining that lawyers will grandstand, that judges will be affected by concerns for their rulings, et cetera. I'd also note in the U.S. that the United States Supreme Court does not allow cameras, which is interesting.
Ever. And ours does.
And ours does, and that's been very, very successful in Canada, and we often use it in the classroom as a terrific teaching tool, but that's focused on legal argument and not on the details of people's lives.
Jean, then Jamie.
Just interesting that I too did a bit of looking at the different history of it in the U.S. and Canada, and there isn't nearly as much of it as I had thought, and especially at the U.S. Supreme Court. And interestingly, where it became a real question in the U.S. was on the Bush-Gore case in the U.S. Supreme Court. So I think there is, getting back to, I think it was Bill Trudell's point, though, about the criminal justice system being a serene place. I think what we're all talking about isn't so much just public watching, is public engagement in the criminal justice system. Because it seems that there is fear behind this. We're all saying there need to be rules, and we're all want protections in there. But ultimately, what I think people fear is that if the public starts watching some of these trials, they're going to start influencing. Look at the O.J. Simpson one as our cautionary tale. I mean, people would weigh in every day on what their opinion was. And I mean, that is the fear, I think, that the public will get involved. But it is the public system. And don't we want a criminal justice system and a civil justice system that is engaged with the public?
Jamie.
Well, sure, it's a public system. It's a public system that can only work if it has evidence. And one of the primary concerns of frontline prosecutors is the ability to get witnesses into court. And certainly there's a tremendous pressure on many witnesses now in very serious violent offenses in this province and across the country who don't want to come to court to testify. And one of their primary concerns is, will they be identified as a source of evidence?
Is there no way to work around that?
I'm sure there is a way to get around it. Cameras in the courtroom, though, makes it quite difficult. I should say, I mean, when we have instances where we have people in the body of the court that have brought in cameras, have secreted them and take pictures of witnesses, that's there to intimidate people. If we have cameras in the courtroom, it's going to make their job a lot easier.
Bill Trudell.
I'm interested in the public engagement. I must say, and I want to say it delicately, but I think it needs to be said, that we live in an environment right now in this country where there's a lot of criticism from politicians about judges not doing their job and a law and order agenda, whether that's right or not. But it strikes me that opening the court, there are judges and there are judges. And
what have you got sitting beside you?
Well,
which one's he?
He has only been wrong once, and it's tonight.
And it's tonight. Okay.
I'm concerned about this. I'm concerned about it's being not just engaging the public, but engaging the politicians in a negative way. And that is that we seem to have politicians who will criticize judges openly and publicly now. And I'm concerned that the televising of a trial and a judge's decision that didn't sort of reflect the agenda that we are living with in Canada is going to open up a real can of worms.
It could give, Judge Wyant, grist to the mill for an unscrupulous politician to, base a campaign against a decision that you made, and some judges may feel they can't fight back because they're not supposed to give interviews, et cetera, et cetera.
But they can do that now anyway, Steve. I mean, they can do that on the basis of newspaper reports and where reporters take only a little bit of what you say, and then the public gets a certain impression that may be in fact incorrect. They can do it by ordering a transcript. So there's nothing different. It gives the public the opportunity, though, to make their own judgment. I mean, I agree with Jamie in terms of the issue of security of witnesses. But to simply say, well, we're just not going to have cameras, that's the easiest way of doing things, really, I think, buries our head in the sand. We're pretty intelligent people. We can come up with rules that protect vulnerable witnesses and deal with the security issues. But this issue about politicians will use it, quite frankly, with all due respect to my friend Bill, I think it's fear-mongering. I'm actually happier to have the public listen to my judgment, watch my reasoning, as opposed to having a journalist take parts of it and manipulate it in a certain way, and then people getting a different impression. I'm not afraid of it.
Do you have cameras in your court in Manitoba?
No, we don't have cameras in our court in Manitoba.
In any courts?
No. And one more thing, though. We've had cameras in public inquiries for many, many years, and no one's complaining that somehow the public inquiries are not being effective and that witnesses are not testifying appropriately.
Mayor Morin.
Yes, 2 points on this. I think there is a concern sometimes with judicial behavior, and so one of the things that I think actually could be useful in terms of cameras in the courtroom, and you referred to this, Ray, is the possibility that people have more of an opportunity to scrutinize judicial behavior. But I think that does raise a danger that has happened in the US, where courts and trials are routinely televised and where judges are also elected, that there is a complication of the legal process, which is supposed to be an assessment on the evidence and an application of the legal rules, and judges are getting feedback in a politicized process where they need people to vote for them. So certainly in the United States, I know that that's been a concern, that it might distort the nature of legal assessments.
I wonder just if I can pick up, Jamie, on the angle of how you make sure that people who you don't want to have identified are not. My recollection is, and I forget how many years ago this is, it's probably 10 anyway, William Kennedy Smith, the nephew of Senator Ted Kennedy in the States, who was on trial for sexual assault against, and the woman who was his victim, alleged victim, I guess, because he ultimately was exonerated, she testified. She was unnamed. She had her face, or I think they only shot her from, hands only as she testified, and they obscured her face as she testified, so she, theoretically could not be identified. Would that work for you?
Well, imagine what the public would think of the integrity of a justice system that had someone with a blurry face talking on screen in the middle of one of the most important and private engagements with the justice system of their lives. I think we have to get back to basics here a bit, because the bottom line is here, if you're going to have people on camera in court, you're dealing with people that are not there by choice. They're there under subpoena, they're there because they've been arrested and they've been compelled by the state to go on trial. And what you're talking about, perhaps, hopefully not, is compelling people to testify on camera against their will. And let's remember what the justice system is. It's supposed to be a truth-seeking mechanism that delivers justice. And what the camera becomes in those circumstances, and certainly can become in many circumstances, is an obstacle to that goal.
Phil.
We don't even have to think about the Smith case. Bernardo, which many of us remember, there are a number of witnesses, women, who testified without identification, their initials only. And they came forward to give very private, personal evidence. CBC brought an application to have that trial public, unsuccessful. And so there's this privacy issue that we have to be very concerned about. But there's another player in the criminal justice system that's more important than really everyone except the accused, and that's the juror. And quite frankly, I asked a juror who happened to serve recently on a case, in a murder case. I didn't ask about the case, but I said, I'm going to be doing this program. What was your experience like? And thoughtful, insightful, absolutely no. Jurors felt, and they actually talked about their privacy, she said.
But even in the OJ case, the jury was not televised.
Well, okay, so are we talking about having a trial, a jury trial where, the jurors aren't filmed, or what do we do here?
The camera was told, don't pan and catch the jury. And I think 99% of the time, that happened. I think I do recall one time where one juror at the front on the end was accidentally shot for 2 seconds.
Okay, but there's an example of jurors saying, we don't want this to happen. We want to come in, do our job, our civic duty, and go away. Same thing with witnesses. You're not going to give witnesses who come forward and with their privacy interests, they just won't come forward.
Mayo.
It's interesting in the polygamy reference that's going on in British Columbia right now. They've worked out a sort of a compromise around this in order to protect the complainants in that case and some of the other sensitive nature of the information. I know Ray wouldn't like this, but it depends on consent. So they've said that closing arguments can be televised and that they're going to have a delay to make sure that no one's identified because they're concerned about the sensitive nature of the information, the fact that those witnesses are very compromised, some of them, in living in their communities. And so they've worked out this very interesting arrangement that I think is really appropriate, that enables the public to see the key issues in the case without compromising the privacy of the individuals.
Jean, let me ask you about this. I mentioned in the introduction of the program, it's been 30 years since cameras were first in the courtroom, and I'm sure everybody around this table, literal and metaphorical, will remember it was the Patriation case when I gather the Supreme Court decided in public, on television, they decided it was an important enough case that they wanted to put it on television so that people could hear their explanations and their judgments. One might have thought that that would have created a certain momentum behind the idea. Now, this is 30 years ago. Why does it appear not to have created enough momentum to get this thing actually done?
Well, I think that, I mean, our conversation here today is maybe an indication of why. There are so many troubling protections that need to be put in place. But picking up on that example, if we look at the cases where the Ontario Court of Appeal has done it, they're not these tough criminal cases that we're talking about. I mean, the most recent one was Stephen Truscott. You know, Stephen Truscott on appeal, and surely that was a situation where him having his opportunity to be cleared in a truly public courtroom, not one where he's drawn with quill pen on a TV screen. Surely that was a fine moment where the public was the TV audience. And one several years ago was about the closing of a hospital near Ottawa. Again, something where I think you do want the community and the public engaged.
I want to go to Bill on that. That's a really great point. Stephen Truscott spent years and years in jail, and to the best of everybody's, I guess as far as the public was concerned, he was in jail for a reason. Did he not deserve that opportunity through a wider television audience, an audience that only television could have provided, to clear his name and recapture his reputation?
Well, that's a very different point, because my position was we're talking about televising a trial where, in the first instance, someone's innocent is going to be decided, and then if they are found not guilty, they can go back in the community. If they're found guilty, they may be punished. This is a historically unique case.
And was on appeal.
And on an appeal.
So would you be okay with appeal?
You know what, I don't think that there's the same problem with appeals, because they're more educative, and they're a really good way for us to understand how the trial took place.
I think he's moving.
I
think he's moving.
I don't really think that's comparable.
Okay.
What I'm talking about is protecting the integrity of the system and witnesses. And just to mention public inquiries. We have lots of public inquiries, and they are open to the public. But the public inquiry, they're inquiring into really what happened. Most terms of references, or all terms of references, they're not affixing blame. They're not going to say this person did that, because that's not what it's about. It's obviously people form their own conclusions, but that's really different.
That's true, but they're presided over by a judge. And judges in those circumstances don't seem to mind being on television. Why would they in a courtroom?
Well, I think it's a different situation, Steve. I think that in a courtroom, you're deciding individual guilt or innocence and responsibility, and people's lives are playing out. In terms of a public inquiry, there's a bigger issue that the public needs to look at, and no one is going to be deciding guilt or innocence.
Okay, Mayo Moran.
I think a good way to deal with and balance these issues is around consent, which is what the legislation does in British Columbia. So I mean, you could easily say in the Truscott case that If the accused was willing to consent to that, then that's fine. But the concerns that I hear are not concerns so much about judges, but about the privacy and confidentiality interests of the litigants, the accused, the witnesses, etc. And consent is a good tool, possibly, to deal with those issues, and that's the route that's been chosen in British Columbia.
Let me ask our director, Michael Smith, here. Top of page 3, Michael. Let's go to this graphic here. It's in the Charter, friends. Here's Section 2 of the Charter. Everyone has the following fundamental freedoms. And then if you go to Section 2B, it says freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Now, Judge Wyatt, there it is in black and white. How come no one's been able to mount a successful case based on that?
Well, I'm not sure, Steve, but you know, the arguments that everyone's using here today are great arguments, but you notice that the people who are opposed to courtroom cameras pick extreme cases to justify their position, vulnerable witnesses or issues of security. They're not talking about the general run-of-the-mill cases that the public can hear where the integrity of the process will not be compromised. I think Mayo's point about the BC reference is a really good one. There's an example where something that's very interesting can be watched by the public, but other than British Columbia and their Supreme Court, we don't even have those rules for judges' decisions in significant cases anywhere in the country. We don't even allow a camera to be on a judge when they're giving a decision that the public is really interested in. And yes, appellate decisions can be very educative, but frankly, as Jean said, many of them are pretty boring. And so I think that the point is, if we have a philosophy where courts are open and are the basic fundamental pillar of our system is open courts, then let's devise a policy that allows that to happen. I don't necessarily agree with consent because I think most of the time people will just simply say no. But you can have a process of judicial review, so where there are cases where it shouldn't be televised, don't televise them.
Jamie, then Bill.
Well, the Supreme Court of Canada has just recently decided this issue in the CBC versus Canada. It's a January 28, 2011 decision. And they well recognize that the freedom of expression supports the freedom of the press, and that there is indeed some worthy content with respect to things that might be captured in that case with respect to the playing back of actual voices from the evidence in court. So by analogy, anything captured by a camera. But the reason this has gone on for 30 years, it's not because it hasn't gone on unchallenged. The Supreme Court and the courts of appeal have always recognized that the public also has a right to an administration of justice that works free of obligation. Free of obstruction. And when they look at the downside of cameras in courtrooms and public watching through the media actual trials in progress, they see that that's a real obstruction, and they found so.
Because you said, Steve, there it is in the Charter, it's black and white. And as Jamie said, it's not black and white.
Nothing is black and white, that's true.
But the court, in those recent cases, the court had to find a balance, recognizing the public's right to know and the media's right to publish. The court had to look at a balance. And in one of the cases, someone who had been found not guilty, case over, appeal order over, the press wanted to publish the statement that person gave to the police. Well, that person's life, had moved out of the system, so the court found the balance. And in the other case, there was rules of the Superior Court where the media could be, where they could hang out in the corridors, which led to scrums, etc. Court found a balance. So it's there. It's so important that it's there so that we don't have justice in the dark.
But it's not the whole story.
No, it's not the whole
Jamie,
story.
come back at him?
There's a rule called the sub judice rule, and it says effectively that if a case is being considered by a court, there can't be any obstruction of that process. And it's raised often when the media is engaged either by the police or by defense counsel or by other interest groups when they're talking about the trial that's in process. And let's just go back to appeals for a minute. You've got a murder appeal that the singular ground of appeal is the admissibility of a statement. And the Court of Appeal, the Supreme Court sends it back saying that this confession, right, is inadmissible. That's out there in the media forever. Anyone can access it, can Google it, can do other things with it. Once that trial's sent back for trial, for real trial, that's out there in the media, you've got the potential problem of a jury panel that's heard it. And what do they do with that?
All right, let me go to Jean in Calgary on this one. Gina, we are hearing not just around this table, but we've heard this many times in the past as well. There's a great deal of mistrust by the people who are the so-called stakeholders in the justice system. And I'm not going to ask you to speak on behalf of all media here, but you are the closest thing we have to media as a guest on the program today. And so I am going to put you on the spot with this one. They don't trust you. They don't trust us. They don't trust us to get it right, to understand the nuances. How big a factor is all that here?
Sure, I think it's a big factor. And first of all, let me say, when the media make mistakes, I am as grieved about it as anyone else. So the media sometimes make mistakes. Lawyers never do, but media frequently make mistakes, and I regret that. But beyond the mistakes, I think the reason goes back to something that one of the panelists has said. It goes back to this idea that journalists are left to interpret what has happened in a courtroom. And in the days when I was actually interviewing more, I would often, a practicing lawyer would tell me, I would ask a question, and the lawyer would say to me, no, that's not the story. That's not the story. And I would often say to that person, well, it is the story for the audience that I'm serving. And I think part of the problem is that we are serving different audiences. And so, something gets lost in translation. And it seems to me that on some of the big public interest cases, there is a reason why, if the public were getting the straight goods. Now, there is danger with that too, and I acknowledge that. But some of the cases where, and I think that the limitation that Bill Trudell has pointed out about the scrutiny by politicians on the judiciary could get difficult in public interest cases. But where the public is engaged already, and cases such as Robert Latimer, seems to be one that the public had interest in from coast to coast. And would it not have been more useful and more constructive if we'd had the cameras running rather than journalists interpreting things that could lead to more error?
Let me pick up on a tangent on that with Judge Wyant here. And I remember interviewing one of your fellow judges, Clyde Wells. After he was Premier of Newfoundland, he was then, I guess, Chief Justice of the Newfoundland Supreme Court. Right. And I asked him, what do you miss about politics? And he said, not a damn thing. And he said, there's something about the court. It is a sacred place. It is a sensible place. It's far away from all of the games and ridiculousness of public life. Would television in the courtroom affect that?
Some would say it could, and I would say properly managed, it won't. And I would say this, it is a sacred place, but for those of us in the system, it's a comfortable place because we're not under scrutiny in the fashion that perhaps we ought to be. And I'll pick up on what Jean said in terms of the interpretation by the media. Public confidence is at an all-time low in this country in terms of its understanding and its faith in the justice system. A lot of that is because, from my perspective, it's because of cases that have been interpreted or misinterpreted by the media. And I think that if the public sees what happens in our courtrooms directly, they'll have a different appreciation of how the justice system works, and that people actually do a pretty good job, and this is a pretty good justice system, and I think public confidence will be enhanced over what it is now.
When you consider, Dean Moran, all of the major institutions of this country, most of them are on television now. One that isn't is the Senate of Canada. So there's the Senate and there's our justice system. Is that the company that the justice system wants to keep?
Well, probably not. The Academy isn't on TV yet. But what I was going to say in response to that, I actually think there is an argument to be made for a lot of it being televised, as I've indicated, subject to privacy, confidentiality concerns. But I'm not very moved by the idea that the public won't find that interesting, and therefore it doesn't satisfy the need for public knowledge. Because my sense is that if we have important legal arguments available and we have trials depicted as much as they don't compromise privacy or confidentiality, then I think we're opening up the justice system in ways that we need to, and I agree about the need for judicial scrutiny, actually. But I wouldn't think about whether or not the public is going to find this scintillating as the right test to think about whether it should be open. I think does it fairly protect the individuals involved in the process, and can we learn something from it? And subject to those considerations, I think a lot could be open.
Let me follow up with Jamie, though, on the earlier point, which was most major institutions in this country are televised now. It's an added layer of scrutiny. It's so we get to look inside and see whether or not you guys are doing your jobs properly and whether we're getting value for our tax dollars and so on. Is it really, is it appropriate in the 21st century for the courts still not to be under that added layer of scrutiny when everything else is?
Well, it's entirely appropriate in these circumstances. First of all, that justice partners, justice participants couldn't be under more scrutiny. The print media, television media are always there at the court. Defense counsel scrutinize the decisions of prosecutors, judges, review everybody's work. It's hard to imagine a public office with more scrutiny. So I don't think...
Really?
Really.
How about being premier or prime minister?
Well, that would be interesting. Not that many people
scrutiny.
get to be those folks. But in terms of I guess 900 frontline prosecutors in Ontario, those people are under intense scrutiny, as are every defense counsel and every judge that sits in their courtroom. It's an open court, okay? But let's remember we don't want to throw the baby out with the bathwater here. Education is a very critical issue with respect to how the justice system works. But by putting cameras in the courtroom without the consent of participants, what you run the risk of is getting rid of the evidence, which is the lifeblood of the whole system.
Let me go to Jean on this. Jean, one of the things that I've heard many politicians over the years tell me that question period was a different thing before they put television in the legislature or on the floor of the House of Commons. You didn't get the kind of histrionics, you didn't get the showboating and the circus performances that you often do today. And they use that as if to say, if we put cameras in the courtroom, people's behavior would change, crowns would be acting up, defense lawyers would get more histrionics, judges, who knows? What's your view on whether or not cameras in the court would change the behavior of those who are in those courts for a living?
Well, I think it would change it could change the behavior. I mean, interesting about the O.J. Simpson trial, the two lead prosecutors left the practice of law after that trial and became media commentators full time. So surely it has the potential to change behavior, but perhaps not in the same way as question period. With question period, what I understand is the criticism is that there are often, as you say, histrionics, but not necessarily the same rigor to the answering of questions. And it seems that in a trial or an appeal, those things still have to be answered. I just want to pick up on, I want to respond to, Dean Moran mentioned, that we shouldn't just be paying attention to whether something is boring or not as the answer, and I do take her point, but I think what's behind boring is something is esoteric. And it seems to me that if we have only the most pure law appeals broadcast on TV, then the public isn't interested because they can't relate to it maybe in the same way. And I think that's where we'd want to at least look at some cases, like the polygamy case, where the public does relate to it.
Let me get Bill Trudell on the issue of whether or not cameras would change the behavior of the lawyers or judges.
I think they would, Steve. For instance, just to let me give you an example. People don't understand that the Crown doesn't win or lose. The Crown presents their case, and it's very difficult for a Crown not to try to win the case, but it's a real balance. I would think that the pressure would be enormous, enormously increased on Crown Counsel.
To try to win.
To change that approach. Secondly, in terms of defense counsel, I'm not concerned about grandstanding. I'm concerned about the effect in the public domain of the next question, whether you call your accused. A lot of trials succeed because of what happens off camera, sometimes in the judge's chambers, where we have to say, we're going to ask this question, but not the following, because there are real security issues, etc. So the criminal justice system and trials are never smooth, because there's always interruptions about legal arguments and things like that. But I'm concerned that and I don't, it's not secret, it's very important. I'm concerned that some of that cooperation and things that are underlying the smooth operation of the trial we'd lose them in public
Can you
hearings.
imagine, Judge Wyant, whether your behavior would change if there were a camera in your courtroom?
I don't anticipate my behavior would change at all. But I could see some people may change their behavior. It actually might make the process more respectable at times in terms of the behavior of participants in the justice
How
system.
so?
Sometimes people take advantage when they're in court because they're not necessarily being watched. And I think the camera can actually be a watchdog in that sense. And in the United States, everyone always wants to turn to the OJ case as if it's the be-all and end-all. But the studies have clearly shown that it hasn't changed behavior. The use of cameras in appropriate cases has not changed behavior and has not affected trial fairness in the United States. The Terry Schiavo case, George Greer, who is the judge on the Terry Schiavo case, has cameras in its courtroom all the time, never complained about it, and that case drew the attention, of course, of people across the world. And I don't think anyone would say that justice was interfered with.
I want to ask Jamie directly whether part of your singular and your general discomfort with cameras in the courts speaks to the fact that the courtroom is a different place. It's not like the rest of society. The rules are different, the language is different, what you do is different, and frankly, you guys all like it that way. And you don't want the rest of us kind of peeking in on your, I don't want to say star chamber, but your secret world where things are different. And you like it that way. Is that possible?
No. Welcome to my nightmare. I'm a prosecutor in Ontario. I'm a frontline prosecutor in Ontario. Across this country, prosecutorial services struggle to remain independent above the pressure that's put on them by victims groups, by police, by politicians. Okay? In many ways, what the justice system needs in this country is to be rescued from politics. Many people view the criminal justice system is more of a game than something that deserves confidence.
Do they do that directly or indirectly?
Do people say that?
The
Sorry.
politicians. You said you feel the pressure to do one thing or another.
Well, the way it plays out is this. Something happens in a trial. It attracts a lot of media attention. And you may well feel pressure coming from an attorney general in some provinces or federally, coming to bear, hopefully not directly on the prosecutor, but certainly the direct supervisor. So that's a natural set of circumstances. The AG is going to want to know what happened. There's going to be a line of communication going north.
And,
Okay.
if cameras were in the court, you say that would be even worse.
Well, it would certainly increase. It would increase the frequency and political exposure to what should be a real justice process. We don't want the system to look like a game. We don't want it to become a game show. And our great fear is that that's indeed what would happen with cameras.
Mayo?
And indeed, I think if Ray uses the example of the United States, and I think across a whole range of areas, judicial appointments, something that we talked about before, et cetera, there is no doubt that the legal and justice system is much more politicized in the United States. And so, the issue of cameras in the courtroom could play a role in that. I don't think most of us view it as a better system.
American one.
Yeah, because it's more politicized. But I was going to come back to the point about how cameras might change behavior. I actually think they could change judicial behavior for the better as well. So I don't want to be too Pollyannish about what's going on in the courtroom. Sometimes we do worry in Canada sometimes that judges don't feel quite enough scrutiny, not for the nature of their decisions, but are they awake, are they paying attention, are they really focused? Of course, not judges like Ray, but it's actually rather difficult to criticize judicial behavior, and I actually think that to some degree one advantage of this would provide a little more sense of what actually judges are doing in the courtroom.
Bill?
Just to pick up on what Jamie said and what Mayo said, that it's not our world, we don't want you to come in. It's just the pressures of every word chosen that may have an effect on a victim or an accused, on their future. And so that's what we're concerned about. We're not sort of saying this is our world, stay out of it. And you should know, Steve, and you probably know this, that the criminal justice system is evolving incredibly right now with mega trials and collaboration between judges, defense, Crown, police, academics. And we're really sort of in a stage where the system is changing in terms of front-end management. So it's a very fluid thing. Our problem is we don't get the message out that it's a very alive people place.
Well, let me try this with Jean. And that question, Jean, wasn't meant to be a smart aleck thing, but the fact is, back in 2007, this Ontario government ran a pilot project on this. They did put some cameras in some court, in the Court of Appeal of Ontario, and apparently The vast majority of those canvassed said it worked well, they liked the idea, they wanted the practice expanded. What happened to the study? It never was made public. Canadian Press had to file a Freedom of Information inquiry in order to get the thing made public. It finally was made public, and the Attorney General said, okay, we'll look at putting more cameras in the courtroom. Given that kind of history, is it any wonder why some people may think people in the justice system have got something to hide?
Well, I guess the trouble, from my point of view, and I'm not speaking for all the media here, but as a citizen, the trouble that I have is that we're talking, for the most part, about making public information public. You know, we're not talking. We're talking about things that can be written about. They can, again, we can have those pencil sketches on a screen. We can, in many cases, have the information afterward. So we're talking about public information. And if we're ever to learn, if the citizens are ever to learn about these pressures or to learn about what the Crown's role is, then what better way to teach us than through television?
One thing we haven't talked about, Judge Wyant, is the cost of this. Would it cost a lot of money to allow cameras in the courtroom?
Well, there'd be some infrastructure costs. Certainly, the one thing you wouldn't want to see is to have 10 cameras, every television or station having cameras and microphones. There'd have to be discussions between court services and the media. You'd have to know who accredited media are. You'd have to put cameras in such a fashion that they didn't create a distraction. But those rules are easily crafted. So, but there certainly would be some money involved in putting the system together.
And do you share any of the concerns you've heard here that ever since they put question period on television, the behavior's gotten worse and we'd see worse behavior in courts?
No, I don't think so, and I'm really pleased that Mayo said what I wanted to say and was a little afraid to say, and that is that I think it could be a real check on the behavior of people in court. And I think the public, someone mentioned, I think it may have been Jamie who said that there was a concern it might become a game. I think the public views it as a game, and I think the opportunity to educate and open up the system with rules, I think, is a tremendous opportunity and one that's well passed. And I go back again, we don't even let judges give their judgments on camera. We haven't even gone that far yet. So this debate, if we can get that far with this debate, terrific.
2 minutes to go. Bill.
I think that this whole idea of we don't do a very good job, so let's bring the television cameras in to educate is an abdication. I mean, we don't do a very good job of explaining how the criminal justice system works, but really, we're jumping way ahead of ourselves. And I don't think that putting cameras in trials is going to solve the problem. Education will solve the problem. Informed media will solve the problem. People who cover trials, who know something about the language and just don't report headlines, will help the public understand.
Do you know what? You know how the public doesn't trust you guys that much to get it right? I don't think they trust us that much to get it right either. That's why they want the camera in there, so they can see not just justice being done, but being seen to be done.
No, I disagree with you, Steve. Quite frankly, I think that the public does trust newspapers, anchors like yourself, and I think the public trusts the criminal justice system. And I really am getting tired, even though I have the greatest respect in the world for Justice Wyant, to say that the public confidence in administration of justice is at an all-time low. I don't think that's fair.
Jamie, you want the last 30 seconds?
Sure. This is going to be an expensive undertaking. Given all the difficulties, the challenges that justice faces across the country, I can't imagine spending money on this and not on other more pressing issues. It can't be that much of a priority for this system. The Supreme Court of Canada has tried to balance these interests and has done so for 30 years, and they've come out with with the idea that people have to consent to go on camera.
Let's give Mayo the last 10 seconds.
So what I was going to suggest is that actually there's an issue with the media, which is that we need more media in this country that are literate in law and are able to translate it. There are many more in the United States, very few in Canada, and I think that's an important role that's going to be part of the public education picture.
On that, we can all agree, and we were lucky to have one of them on this program today. Jean Cumming from Lexpert out in Calgary, Alberta. It was good of you to join us on the line, Jean. Thanks for being there, okay? And here in our studios, Mayo Moran, the Dean of the U of T Law School, Jamie Chafe, the President of the Canadian Association of Crown Counsel, and on the other side of the table, Judge Ray Wyant, the former Chief Judge of Manitoba, Bill Trudell, Chair of the Canadian Council of Criminal Defense Lawyers. Thanks so much, everybody. Great to have you here tonight.
Thank you.